Chapter 16. Formalities of entry in and exit from the Philippines. Case of the overstaying alien. Kim Jeb-boon is a 21-year-old Korean student enrolled in a school in Manila. She is expecting to finish her hotel and restaurant management course within 4 years, the period granted by the Philippine government on her student visa. On her final semester, Kim got very ill and was hospitalized for 2 weeks. This situation forced her to drop her subjects in the university. Her stay in the country would necessarily be extended in order to complete her studies. Thus, she would probably finish her studies in October instead of March. Kim failed to seek good advice from the agency that was taking care of her visa requirements, causing her visa to lapse. When she got better in the summer and was about to enroll for the first semester of the next school year, the registrar noted that her visa was lapsed and Kim is now regarded as an overstaying alien. The entry and admission of foreigners into the Philippines are matters of privilege, because every foreign state has absolute and exclusive power of government in its own territory. Although entitled to all the rights and privileges of a friendly guest, they cannot claim the right to enjoy privileges, which by their nature belong exclusively to the host. The law. Commonwealth Act No. 613. The Philippine Immigration Act of 1940. In Section 10, it states that non-immigrants must present for admission into the Philippines on an expired passport or official documents and the nature of passports issued by the government of the countries to which they owe allegiance or other travel documents showing their origins and identity as prescribed by regulations, and valid passport visas granted by diplomatic or consular officers. Discussion of the law. Non-immigrants must present unexpired passports and valid visas prior to their admission into the Philippines. The Philippine Immigration Act provides 7 visa categories for non-immigrants, namely 1. Temporary visitor, 2. Transient, 3. Seaman, 4. Treaty trader or treaty investor, 5. Foreign government official, 6. Student, and 7. Pre-arranged employment. An alien is allowed only one immigration visa category at any given time. So before we tackle any further, let us know first about the passports. What is a passport? A passport is defined as an official document of identity and nationality issued to a person intending to travel or sojourn in foreign countries. It is the property of the government of the issuing authority. It is not a private property of the person to whom it has been issued. There are 3 types of passports, namely A. Diplomatic passports, B. Official passports, and C. Regular passports. First, the diplomatic passports. These are issued for persons imbued with diplomatic status or are on diplomatic mission. Next is the official passports, are issued to all government officials and employees on official trip abroad, but who are not on a diplomatic mission or delegates to international or regional conferences, or has not been accorded diplomatic status. Lastly, the regular passports are issued to private persons who are not eligible to diplomatic or official passports, including government officials or employees going abroad for pleasure or other personal reasons. The visa requirements. Visa is a written endorsement made on a travel document or passport by a consular official denoting that the visa application has been properly examined and that the bearer is permitted to proceed to the country of his destination. The visa thus issued is not a guarantee that the holder will be automatically admitted into the country, because the admission of foreign nationals into the Philippines is a function of the immigration authorities at the port of entry. Executive Order Number 63, granting incentives to foreign investment in tourist-related projects in tourist establishments and for other purposes. The discussion. The investor, his wife, and unmarried minor children shall be permitted to enter and reside in the Philippines as special investor residents for as long as the investment of $50,000 subsists, provided that 1. They have not been convicted of a crime. 2. They are not convicted to any loathsome, contagious, or dangerous diseases. 3. They have not been institutionalized for any mental disorder or disability. And provided further that the said investor visits the country at least twice a year and stays in the country at least 7 days for each visit. The said investor, his wife, and unmarried minor children shall be issued a multi-entry special investor resident visa to enter and leave the Philippines without further documentary requirements other than the valid passports or other travel documents in the nature of passports. They shall be exempt from payment of alien immigration and registration fees and from securing alien certificates of registration. On May 7, 1999, the National Bureau of Investigation, in coordination with the Department of Labor and Employment and the Bureau of Immigration, conducted simultaneous raids at the Royal Flame Club, Space World, and Narcissus Club in Ermita, Manila. 20 female Chinese nationals were caught in the act of entertaining customers and guests for violation of Section 37 of the Philippine Immigration Act of 1940, or violation of any limitations under which they were admitted as non-immigrants. One of the violators was a Chinese national named Ma Ting. It appears that she is not really an undocumented alien, as she has a valid BROC passport number 143777 and visa number 1201, issued by the Philippine Embassy on March 18, 1999. Her stay in the Philippines has been duly extended. She was not notified of the charges against her, nor was she afforded due process. No commitment order was issued by the Commission of Immigration or any competent authority to justify her continued detention. The detention of Ma Ching is to be then considered illegal, for she was accused without warrant of arrest. Extension of stay. In the case of non-immigrant visa holders whose stay in the Philippines will exceed 59 days, the consular officer shall advise them that they should secure extensions of stay and register with the Bureau of Immigration and pay the necessary immigration fees. The entry and admission of an alien are matters of privilege, and there is no ministerial duty on the part of the Commissioner of Immigration to extend the stay of a temporary visitor. The power of the Commissioner of Immigration to extend the stay of the temporary visitor is plenary. He is vested with the power and authority to grant such extension. Therefore, the Secretary of Foreign Affairs is not authorized to admit into the Philippines aliens for temporary stay or to extend the temporary stay of alien visitors in this country, as the law vests such power in the Commissioner of Immigration. The Philippine Immigration Act of 1940, Section 13, Immigrants. Under the conditions set forth in this act, there may be admitted into the Philippines immigrants, termed as quota immigrants, not in the excess of 50 of any one nationality or without nationality for any one calendar year, except that the following immigrants, termed non-quota immigrants, may be admitted without regard to such numerical limitations. The discussion. The corresponding Philippine consular representative abroad shall investigate and certify the eligibility of a quota immigrant previous to his admission into the Philippines. Qualified and desirable aliens who are in the Philippines under temporary stay may be admitted within the quota, subject to the provisions of the last paragraph of Section 9 of this Act. Cha Yong-fa was admitted to the Philippines on pre-arranged employment as immigrant, with the express condition that his stay shall be limited to 2 years, and should he fail to comply with said condition after the expiration of that period, he shall be subject to deportation. The Philippine Immigration Act of 1940. Section 29. Exclusion of foreigners. The following classes of aliens shall be excluded from entry into the Philippines. 1. Idiots or insane persons and persons who have been insane. 2. Persons afflicted with a loathsome or dangerous and contagious disease, such as epilepsy. 3. Persons who have been convicted of a crime involving moral turpitude. 4. Prostitute or procurers or persons coming for any immoral purpose. 5. Persons likely to become public charge. 6. Paupers, vagrants, and beggars. 7. Persons who practice polygamy or who believe in or advocate the practice of polygamy. 8. Persons who believe in or advocate the overthrow by force and violence of the government of the Philippines, or of constituted law and authority, or who disbelieve in or are opposed to organized government, or who advocate the assault or assassination of public officials because of their office, or who advocate or teach principles, theories, or ideas contrary to the Constitution of the Philippines, or advocate or teach the unlawful destruction of property, or who are members of or affiliated with any organization entertaining or teaching such doctrines. 9. Persons over 15 years of age, physically capable of reading, who cannot read printed matter in ordinary use in a language selected by the alien. 10. Persons who are members of a family accompanying an excluded alien, unless, in the opinion of the Commissioner of Immigration, no hardship would result from their admission. 11. Persons accompanying an excluded person who is helpless from mental or physical disability or infancy, when the protection or guardianship of such accompanying person or persons is required by the excluded person, as shall be determined by the Commissioner of Immigration if otherwise admissible. 12. Children under 15 years of age unaccompanied by a parent, except that any such children may be admitted in the discretion of the Commissioner of Immigration if otherwise admissible. 13. Stowaways, except that any stowaway may be admitted in the discretion of the Commissioner of Immigration if otherwise admissible. 14. Persons coming to perform unskilled manual labor in pursuance of a promise or offer of employment, express or implied, but this provision shall not apply to persons bearing passport visas authorized by Section 20 of this Act. 15. Persons who have been excluded or deported from the Philippines, but this provision may be waived in the discretion of the Commissioner of Immigration, provided, however, that the Commissioner of Immigration shall not exercise his discretion in favor of aliens excluded or deported on the ground of conviction for any crime involving moral turpitude, or for any crime penalized under Sections 45 and 46 of this Act, or on the ground of having engaged in hoarding, black marketing, or profiteering, unless such aliens have previously resided in the Philippines immediately before the exclusion or deportation for a period of 10 years, or more or are married to a native Filipino woman. 16. Persons who have been removed from the Philippines at the expense of the government of the Philippines as indigent aliens under the provisions of Section 43 of this Act, and who have not obtained the consent of the Board of Commissioners to apply for readmission. And 17. Persons not properly documented for admissions as may be required under the provisions of this Act. International law affords the sovereign states absolute discretion to determine whether or not an alien is disqualified for entry into its territory. As a general rule, an alien's fitness for an entry depends on whether he or she possesses a risk to the general welfare. If an alien's entry will threaten national security, public safety, public health, and public morals, then the state can declare such alien as being ineligible for entry. Exclusion is defined as the authority to deny entry to aliens who are barred by immigration laws, rules, and regulations. The purpose of exclusion is to ensure that the aliens who are allowed to enter to the Philippines do not pose as threats to any of the three major categories of exclusion grounds, namely 1. Public safety, 2. Public health, 3. National security. As a general rule, an order of exclusion is final and executor, and bars the alien from entry or admission into the Philippines unless waived by the Commissioner of Immigration under Section 19 of the Philippine Immigration Act of 1940. The three petitioners, Dolores, Felix, and Bandwal, all surnamed Miria, arrived in Manila from Hong Kong on board Cathay Pacific Airways on July 9, 1961. The matter of the admission of the three was referred to the Board of Special Inquiry No. 1, which after the investigation found Dolores Niria to be a Filipino citizen and Felix and Manuel Niria to be her illegitimate minor children by Chinese national Gan Chongbing, and accordingly voted to admit them. Pursuant to Section 27 of the Philippine Immigration Act of 1940, the decision admitting Dolores, Felix, and Manuel Niria was forwarded for review to the Board of Immigration Commissioners. On September 1, 1961, the three explicitly and uniformly recite that they had been admitted as citizens of the Philippines as per decisions of the Board of Special Inquiry, duly affirmed by the majority members of the Board of Commissioners. On August 8, 1962, a new BIC reviewed the proceedings of the Board of Special Inquiry with respect to Dolores, Felix, and Manuel, finding they have not satisfactorily established their claim to Philippine citizenship, ordered them excluded as aliens not properly documented for admission pursuant to the provisions of Section 29 of the Philippine Immigration Act of 1940. The Philippine Immigration Act of 1940. Section 37. Deportation of foreigners. The following aliens shall be arrested upon the warrant of the Commissioner of Immigration or any other officer designated by him for the purpose and deported upon the warrant of the Commissioner of Immigration after a determination by the Board of Commissioners of the existence of the grounds for deportation as charges against the alien. 1. Any alien who enters the Philippines after the effective date of this act by means of false and misleading statements or without inspection and admission by the immigration authorities at a designated port of entry or at any place other than at a designated port of entry. 2. Any alien who enters the Philippines after the effective date of this act who was not lawfully admissible at the time of entry. 3. Any alien who, after the effective date of this act, is convicted in the Philippines and sentenced for a term of 1 year or more for a crime involving moral turpitude committed within 5 years after his entry to the Philippines, or who, at any time after such entry, is so convicted and sentenced more than once. 4. Any alien who is convicted and sentenced for violation of the law governing prohibited drugs. 5. Any alien who practices prostitution or is an inmate of a house of prostitution or is connected with the management of a house of prostitution or is a procurer. 6. Any alien who becomes a public charge within 5 years after entry from causes not affirmatively shown to have arisen subsequent to entry. 7. Any alien who remains in the Philippines in violation of any limitation or condition under which he was admitted as a non-immigrant. 8. Any alien who believes in, advises, advocates, or teaches the overthrow by force and violence of the government of the Philippines or of constituted law and authority of who disbelieves in or is opposed to organized government, or who advises, advocates, or teaches the assault or assassination of public officials because of their office, or who advises, advocates, or teaches the unlawful destruction of property, or who is a member of or affiliated with any organization entertaining, advocating, or teaching such doctrines, or who in any matter whatsoever lends assistance, financial or otherwise, to the dissemination of such doctrines. 9. Any alien who commits any of the acts described in sections 45 of this act, independent of criminal action which may be brought against him, provided that in the case of alien who, for any reason, is convicted and sentenced to suffer both imprisonment and deportation, said alien shall first serve the entire period of his imprisonment before he is actually deported, provided, however, that the imprisonment may be waived by the Commissioner of Immigration with the consent of the department head and upon payment by the alien concerned of such amount as the Commissioner may fix and approve by the department head. 10. Any alien who, at any time within 5 years after entry, shall have been convicted of violating the provisions of the Philippine Commonwealth Act numbered 653, otherwise known as the Philippine Alien Registration Act of 1941, now Alien Registration Act of 1950, or who, at any time after entry, shall have been convicted more than once of violating the provisions of the same act. 11. Any alien who engages in profiteering, hoarding, or black marketing, independent of any criminal action which may be brought against him. 12. Any alien who is convicted of any offense penalized under Commonwealth Act numbered 473, otherwise known as the Revised Naturalization Laws of the Philippines, or any law relating to acquisition of Philippine citizenship. And 13. Any alien who defrauds his creditor by absconding or alienating properties to prevent them from being attached or executed. Deportation is the expulsion or grounds of a foreigner from the territory of a state. It contemplates a foreigner who gained legal entry, admission, or residence of the country, but whose presence therein has become unattainable because of some serious infractions of the municipal law of such country. The right of this state to admit aliens includes the right to expel them. Deportation of foreigners may be effective in 2 ways. 1. By order of the President after due to investigation, pursuant of the old 1917 Administrative Code, Section 29. 2. Through the Commissioner of Immigration upon recommendation by the Board of Commissioners under Philippine Immigration Act of 1940, Section 37. No alien shall be deported without being informed of the specific grounds for deportation, nor without being given a hearing under rules of procedure of being prescribed by the Commissioner of Immigration. In deportation proceeding involving the entry of an alien, the burden of proof shall be upon the alien to show that he entered the Philippines lawfully, and the time, place, and manner of such entry, and for this purpose he shall be entitled to a statement of the facts in connection with his arrival, shown by any record in the custody of the Bureau of Immigration. Among the 22 suspected alien pedophiles in Pagsanhan, Laguna were petitioners Andrew Harvey, John Sherman, 52 and 72 years, both American nationals, and Adrian van Aelschout, 58 years old, a Dutch citizen, were apprehended after 3 months of close surveillance by Commission on Immigration and Deportation agents. Seized during petitioners' apprehension were rolls of photo negatives and photos of suspected child prostitutes shown in salacious poses, as well as boys and girls engaged in the sex act. There were also posters and other literature advertising the child prostitutes. On March 4, 1988, deportation proceedings were instituted against the petitioners for being undesirable aliens under Section 69 of the Revised Administrative Code, and on March 7, 1988, warrants of arrest were issued by the CID Commissioner Santiago against petitioners for violations of Sections 37, 45, and 46 of the Immigration Act. On the same date, the Board of Special Inquiry commenced trial against petitioners. In this case, warrant of arrest by Commissioner Santiago was considered valid. The Philippine Immigration Act of 1940. Section 25. Detention of foreign travelers. For the purpose of determining whether aliens arriving in the Philippines belong to any of the classes excluded by the immigration laws, the examining immigration officers may order such aliens detained on board the vessel, bringing them or in such other place as the officers may designate. Such detention to be for a sufficient length of time to enable the officers to determine whether they belong to an excluded class, and the removal to such other place to be at the expense of the vessel bringing them. Under Section 6 of the Philippine Immigration Act of 1940, immigration officers may detain aliens on board a vessel conveying them into the Philippines. The detention shall be for a sufficient period of time to enable the immigration officers to determine whether a. the aliens concerned belong to any of the excludable classes in Section 29, or b. the aliens concerned may apply and qualify for waivers of their exclusion from the Commissioner of Immigration. In the event the aliens are excludable, the vessel conveying them shall answer for their transportation charges. Under Section 28, government medical and quarantine officers are also allowed to observe or examine whether or not arriving aliens afflicted with any of the disease or mental or physical defects or disabilities that render them unfit for entry or admission to the Philippines. They shall certify their findings for the information of immigration authorities. In the absence of government medical or quarantine officers, immigration authorities may seek the assistance and services of private physicians. On December 30, 2000, 22 people died in serious bombings in Metro Manila, including a boy named Emmanuel. In these regards, the immigration authorities issued a red alert instruction for the temporary detention of foreigners arriving in the Philippines to enable immigration officers to determine whether these foreigners belong to the excludable classes covered under Section 29 of the Philippine Immigration Act. All the foreigners, including Algaz from Indonesia, were temporarily detained by immigration authorities, pending his entry in the Philippines. Upon inspection of his bags, Algaz had it bomb components. In this matter, Algos may be classified as an excludable alien who may pose a risk to the general welfare. The Philippine Immigration Act of 1940, Section 22A, Exit Requirements. Issuance of certificate. Any alien about to depart from the Philippines temporarily or for permanent residence abroad shall, before leaving the country, apply to the Commissioner of Immigration for a clearance certificate. If the Commissioner finds that the applicant has no pending obligation with the government, its instrumentalities, agencies, and subdivisions, and that there is no pending criminal, civil, or administrative action which, by law, requires his presence in the Philippines, the Commissioner shall issue the certificate upon surrender of the alien or all other certificates previously issued to him by the Bureau of Immigration showing his admission and or residence in the Philippines. No foreign shall depart from the Philippines except at a port of departure and unless there has been issued a valid immigration clearance certificate or a certificate of exemption in his favor. Failure to comply is penalized by the Immigration Act. The immigration clearance certificate allows immigration authorities to monitor all the departure of aliens from the Philippines as one major source of income for the efficient administration and enforcement of immigration law, rules, and regulations. The following are exempted from securing immigration clearance certificates. 1. Alien deported from the Philippines or aliens under deportation proceedings who are given permission to depart at their own expense in lieu of deportation to a specified destinations and are departing to such destination. 2. Alien minors under 14 years of age. And 3. Alien transcends or temporary visitors staying in the Philippines for less than 15 days. Republic Act No. 9225, the Dual Citizenship Law. Citizenship Retention and Reacquisition Act of 2003. Under this law, natural-born citizens of the Philippines who became citizens of another country shall be deemed not to have lost their Philippine citizenship under conditions provided therein. Coverage. These rules shall apply to former natural-born citizens of the Philippines, as defined by Philippine law and jurisprudence, who have lost their Philippine citizenship by reason of their naturalization as citizens of a foreign country. Consequently, they must file a petition under oath to the Commissioner of Immigration for the issuance of a identification certificate. Former natural-born citizens living abroad may file the petition to the nearest Philippine Foreign Post. A copy of the birth certificate authenticated by the National Statistic Office is required to be submitted as proof of being a natural-born citizen of the Philippines. So here are my insights about this chapter. Through the existence of these laws, rules, and regulations about the formalities of entry in and exit from the Philippines, it regulates the entry, stay, and exit of foreign nationals in the country. It controls the movement of persons to, from, and within our country in contributing to national development. It also monitors the entry and exit of Filipino citizens in compliance with Philippine laws and other legal procedures. And lastly, and the most important above all else, it secures the tranquility of the state against foreigners whose presence or stay may be deemed threats to national security, public safety, public morals, and public health. So that would be all, and thank you for listening.